Hi, everybody. I'm live. Hi, please welcome to my stream.
Of the jury firmly believes that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service.
All rise for the court, please.
Right now, what you're seeing, all have been told to rise by Judge Canoni after she has declared a
I'd like to pick a
mistrial.
status date to find out what our next.
As you can see, they are still proceeding
So I'd
in
like
court.
to
But again, Judge Canoni
maybe the end of
officially announcing that this is now been declared
I
a
understand
mistrial.
people
The
have
jury
too.
still told her that there was a deep division due to, quote,
come in the
sincere
week of the
adherence to
21st?
personal convictions. And so
I-
now this is where they are. They're still giving the jury in the court any final instructions now, but this has officially been declared a mistrial. She acknowledged that the jury has done pretty much at this point, Cheryl, everything that they could.
That's right, Courtney. And, you know, you can see, obviously, this is very emotional for everyone involved, for Karen Reed and her defense team, but also for John O'Keefe's family. You can see here, I believe that's his mother, seems visibly upset. The judge now is giving a status date to come back to court, which I believe is going to be the end of July.
Okay.
Okay, the 22nd.
How do I
and
feel?
25th.
You know, I feel that there was significant evidence.
Wow.
Now, what you're
Crazy.
seeing here, Cheryl, as you said, emotions are
No,
high. So
Um,
you're seeing emotions from inside of the courtroom, right? And these are people who have been in court every day for countless days through more than 70 witnesses and more than 600 pieces of evidence. And what you just saw there a few moments ago were some of the people who have been rallying outside of the courtroom. Cheryl, such a juxtaposition of emotions.
For sure. I mean, you know, as we've been talking about for quite some time, I mean, this case is super polarizing. I mean, people strongly believing that Karen Reed did hit John O'Keefe and he later died in the snow. And there are others that believe that this is part of a big conspiracy and a police cover-up and a shoddy investigation, and she's not guilty. So she's just, at this point, the judge is doing what's called housekeeping and giving dates to come back to court for a status hearing.
Thank you. We'll see you then.
All rise.
Looks like that's going to be at the end of July. Now, after a mistrial in these cases, the prosecution has to decide whether or not they will try Karen Reed again and what charges they will bring forth, whether they bring them all again or whether they decide to cull through some of the charges and just proceed with those. But you could see right there, Karen Reed hugging her family, supposedly right there. Very emotional for everybody. These are tough cases. I mean, the jury did the best they could, listening to all of the evidence, trying to come up with a consensus. It has to be beyond a reasonable doubt. It has to be unanimous. And that's a very tall order in a case like this, where there's been just so much information from both sides that's really colored people's opinions on what they think actually happened here.
And this has been, as you said, a very complex case for a jury to have to go through and all come to a unanimous decision, which is why, you know, they have come to the judge more than once to say, hey, we have really tried to consider all of the evidence that has been presented to us, but we are still deeply divided.
Right. And, you know, that's why the judge gave the instruction this morning, which is basically called a dynamite instruction. It's supposed to break the log jam that jurors are feeling when they cannot come to a decision, basically telling them what their responsibility is, you know, advising them to listen to each other and to try to come to a consensus if they're able to without compromising their convictions. And they came back and said that they were not able to do that. So at this point, there's no further need to continue to deliberate, and that she declared the mistrial. Now, at this point, you still have a Boston police officer who was dead. You know, you still have quite a bit of evidence that the Commonwealth has put forward saying that they believe that Karen Reed hit him during a snowstorm. He later was found dead on the front lawn of another Boston police officer. And that's the evidence that they put forward. A lot of conflict with that evidence, timing, text messages, some of the evidence put forth with the state police investigators, that people believe that there were conflicts there, that he knew some of the witnesses, the lead investigator, that he made some comments that were derogatory and unprofessional in the words of the prosecution, as to whether or not any of that gets played into the next trial and how that would unfold at this point. And also, you also have the Karen Reed defense team, who believes strongly that this was a conspiracy and that something else happened to John O'Keefe, that he did go into the home and there was some type of a fight. And I think that they're looking at all of that evidence in a way that they, like you said, saw that there were a lot of conflicts here. And that's part of the problem.
And right now, we want to get you right out to WBZ's Penny Commit, who has been covering this case. She joins us live outside of the Dedham Courthouse, where we did show you very briefly emotions were running high outside of the courtroom. And Penny, what is it like out there right now? What are you seeing? What are you hearing?
Absolutely.
The judge just actually announcing a mistrial. And, I've been out here for 3 months now. I've seen this crowd. I've seen the way they've crescendo, they've built over the weeks. And I want to talk to Rita Lombardi. She's one of the leaders of this movement. I know you guys erupted in cheers, but this wasn't the outcome you guys were looking for.
Absolutely not. We were expecting a not guilty verdict. All of the evidence that the defense put on, all of the cross-examination that the defense did with the mostly pathetic prosecution witnesses. Karen Reed did not kill John O'Keefe. It's that simple. She was framed. And we were hopeful that a jury, that was our last hope, that the jury would come back with a unanimous not guilty verdict. But we accept a hung jury because we know it was either not guilty or a hung jury. Guilty was never an option in this case because you were never going to get 12 jurors to go along with what the prosecution put forward, with the planting of evidence and all the nonsense. And I hit him. She did not say I hit him.
Well, thanks for your time, Rita.
Yes.
Thanks for talking to us. And guys, a huge eruption out here after that mistrial was declared. Remember, these jurors have been deadlocked. This was several days of deliberation. And I will say this deliberation pretty on par with some other major trials in Massachusetts. It took the jurors several days. The judge sent them back twice, but officially a mistrial declared out here, guys. The atmosphere, I will say, we expected a lot of movement. I think it's a little still. I think people wanted an answer. I think people wanted some sort of closure. And even though it's a mistrial and there is some eruption, I don't know if they got that closure today.
And we're now getting ready to hear from Karen Reed for the first time after this has been declared a mistrial. Let's listen.
Quick reaction. Yes, quick reaction.
Yeah, they went to the steps.
Hi, Sean B.
Happen in court and what will happen going forward. But it looks like here they are walking out among the crowd there. A lot of supporters outside, people on both sides. Emotions running high in a case like this, always, but especially after a mistrial. I think everyone hoping to get some type of resolution. You heard her supporters saying that they believed it was going to be a not guilty. I'm sure John O'Keefe's family and the prosecution believed that they would be getting a guilty verdict today.
And hearing from Rita Lombardi, one of the Karen Reed supporters, you're right. It's a reminder that this case has been declared a mistrial, but it is not over. It is far from over for both sides, for John O'Keefe's family, as well as Karen Reed's family and supporters.
Right. And at this point now, the prosecution has a decision to make. Will they retry her? We don't know what the court calendar is like. We heard the judge set a status date for the case for the end of July. At that time, presumably, or before then, the prosecution will make a decision as to when and how they'll be going forward in the case. A lot still to consider.
Now, for viewers tuning in who are wondering, okay, if we start this process all over again, Cheryl, what could this look like? I know you spoke a little bit about the calendar and seeing, because there has to be time to do this, but what could this whole process look like, considering that a considerable amount of time and money has already been spent?
Well, I mean, the process will continue however the prosecution wishes it to. I mean, they have all the charges to take a look at. They have a second-degree murder charge, which some people felt like it was an overcharge in this case. You know, they have the manslaughter charge. They have leaving the scene after personal injury and death. A lot to consider. And I know that we have one of our experts that we've been using, former Judge Jack Lew, on the line. And Judge, would like to get your reaction to what's happened today.
I'm here.
Great. Judge, it's Cheryl Fiandaca. Can you hear us okay?
Hi, Courtney and Cheryl. I can hear and see you. A little bit of a delay.
Great. Okay. So what did you think about the judge's decision to call a mistrial in this case?
I think the judge handled it perfectly. This is a obviously this case may be one of a kind, but the judge I think handled it perfectly.
And so what do you see happening next?
It sounds like the judge set a late July status date. I think there are a couple of different options. So the judge might want to just set a trial date and maybe some interim dates, or it could be that the defense is going to appeal on the sufficiency of the evidence, or attempt to appeal on the sufficiency of the evidence. The fact that the jury could not agree, that there was a hung jury, increases the chances that kind of an appeal might be successful. So those are the two. If that second thing happens, it could take a year, 2 years.
Ooh.
So there's still a little bit of time there, Judge, that something more than another trial could happen. There could be an appeal that would have a decision in this case as well.
Yeah, it improves that, they can really go up on appeal and say the evidence is insufficient. And the defense here is amazing, of course. And they've shown that they're very aggressive. It's tricky. It is tricky. You're taking calculated risks all day long, representing either side in a case like this. And the defense is taking chances. For one thing, by wanting the mistrial. That's a big tactical and strategic choice.
Why do you think they made that decision?
I think they have, on an issue like this, as you know, the client really makes the decision, because it's a big decision. The little decisions the lawyer can make without even consulting the client. But the big decisions the client makes, so the client must have approved this, or maybe the lawyer, there is a theory that for defense lawyers, they'll say something like this: every day that your client is not dragged out of court in chains is a good day in the work of a criminal defense lawyer. So they may think, hey, if they don't, let's take a mistrial and we'll come back on another day. And it cannot be considered as a win for the prosecution.
Now, Judge,
but on the second trial, it's unclear.
Now, Judge Jack Lew, we do want to thank you for your perspective and helping to give our viewers a little bit more of understanding about what could be next. But we do want to take you back out to WBZ's Christina Rex, who also has been covering this trial from day one. Christina.
What's going on with the internet?
Now, it does appear we're having some technical difficulties here with audio, so we're just going to hang on because we know we are going to come back to Christina. She would have a lot of. Do you have us now? There we go. There she is. We can hear Christina. Christina, go ahead. Okay, so right now it does appear that we lost Christina again, but we are going to keep trying because, again, Cheryl, she has been following this case from the very beginning. She's been in the courtroom. She's been outside of the courtroom. She's been following and helping to make this case digestible for everyday viewers. So we will get back to her shortly.
Right. And I'm sure she's gathering information, talking to the families, talking to supporters, talking to the prosecution, talking to the defense team, just getting a perspective from everyone here about what's happened. I think that, you know, part of what when you look at this and how polarizing the case has been, I don't know that there's any real surprise that this has happened. I mean, we saw the jury came back not once, but twice saying that they weren't able to make a decision, that they were really struggling with their convictions. The judge issuing what's called the dynamite instruction. It's called Tui Rodriguez also, which basically says to the jury, we need you to make a decision. You have all the evidence that you need. You have all of the information. No other jury could come forward that would have more information to make the decision in this case. And yet they still came back and said, we are still very settled in our convictions and we're not able to come to a unanimous decision.
Now, I do think it was interesting for our viewers as well, Judge Liu bringing up the fact that defense could appeal.
Right. So they can appeal based on what the sufficiency of the evidence, basically saying that this jury could not find that there was enough evidence to convince them beyond a reasonable doubt that she's responsible for the death of John O'Keefe. And at this point, I think we have Christina Rex outside. So let's go back out to the courtroom and see the courthouse and see if we can chat with her.
Yeah, Cheryl and Courtney, hopefully you guys can hear me now. I've been inside that courtroom every day for 10 weeks during the trial when the judge just declared a mistrial in that courtroom. And I've been careful not to, you know, really.
What the hell's going on with the shit over there in court TV? This is terrible.
Certainly looked defeated. The judge was somber, just kind of a heavy air in that courtroom this afternoon when that mistrial was just declared. And then there's really no better way to describe the difference from the course of this trial until today's end result than out here today. Every day, right? It's been beautiful sunny weather. The defense attorneys have been very forthcoming about speaking to the media, even celebrating what they called their wins over the course of this trial. Today, you come outside, it's absolutely downpouring rain, some thunder, and then the defense attorneys came out. Alan Jackson gave a very brief statement, didn't take any questions. David Yannetti also gave a very brief statement. Both of them really, to a degree, calling this a victory on their end and saying the prosecution failed. Different environment out here, and that, you know, we tried to ask Karen Reed how she felt now that this actually isn't over. Over the course of this trial, she's been willing to speak with reporters. I've spoken with her many times outside, and she's said, I just can't wait for this to be over. It's not over. You know, a mistrial is the opposite of this being over. There's already another court date for the end of this month scheduled, and Karen Reed said nothing on her way out of court. We don't know if the O'Keefe family maybe exited privately. They have been very private in not speaking with media folks or really engaging in anything going on outside of this courthouse. And as you know, there has been so much activity outside of this courthouse. So we don't know if they'll be coming out this front door or if they exited privately out the back door. But, you know, you go through a trial that lasts this long and all parties involved, you know, just wanted some kind of resolution. Obviously, they wanted different resolutions, and this really provides no resolution, no closure for anybody here. So we're outside the courthouse now. We're kind of waiting to see what happens, reaction from folks involved in this case, and we're going to bring it all to you as it comes.
WBZ's Christina Rex reporting live outside of the courthouse in Dedham. We do want to just say one quick thing before we get you over to WBZ Tammy Mutasa. Cheryl and I just looking at this, just coming into our inbox here. We have the Norfolk DA's office officially declaring this a mistrial, but also pointing out that the Commonwealth intends to retry the case. This just coming into our newsroom. But we do want to get you right to WBZ Tammy Mutasa, who also joins us live in Dedham right now. Tammy.
Be allowed to.
Okay, we are having some technical difficulties, but we do want to get back to this email here from the Norfolk District Attorney's Office. So it does state that Judge Beverly Cannoni, she set a conference date, which we spoke about, that status update of July 22nd at 2 p.m. And right now we have our producer telling us that we do have some new sound from Karen Reed right outside of the courtroom after this announcement. Let's take a listen.
The Commonwealth did their worst. They brought the weight of the state based on spurious charges, based on compromised investigators and compromised witnesses. This is what guess what? They failed. They failed miserably, and they'll continue to fail. No matter how long it takes, no matter how long they keep trying, we will stop fighting. We have no quit.
Alan, you're going to stay on?
Go ahead.
I just have two things to say, folks. Number one, I am in awe of the strength and courage of this remarkable client that I've had the privilege of representing since day one. And number two, I want to send a message to all of her supporters out there. Your support was invaluable, touched, and we ask for your continued support. I'm not from Texas like my colleague here. I'm a Boston kid, but I'll repeat what he said, which is we ain't got no quit.
And what you just heard there, you're hearing from Karen Reed's legal team. Now, Cheryl, we have talked a lot about, Rex included, that there's no resolution here. There's no conclusion, but the tone we're hearing there sounds like a celebratory one. You just heard, remember her legal team say, you know, we ain't got no quit, and they're thankful to the supporters.
Right. Right. And, you know, they're saying that they believe that the prosecution failed. So they're considering the mistrial a win for them. Mm-hmm. Tammy Mutasa is outside of court, our WBZ reporter. She's been covering this quite a bit, too, and she shares what she's learned in this case.
Cheryl and Courtney, we were out here with this big crowd when that mistrial was declared. A lot of mixed emotion, a lot of tension. You can see right behind me, state police are still here barricading this area where a lot of Karen Reed supporters have been camping out, have been cheering, have been chanting. We talked to many people today after this mistrial was declared. Some people say they are ecstatic. Other people say they were convinced for a not guilty verdict. But we also talked to supporters for Officer John O'Keefe who have been showing up in the last few days to challenge Karen Reed supporters and their behavior, saying, you know, a hung jury is better than a not guilty verdict because Officer John O'Keefe deserved justice and he was the victim in this case. Again, a lot of Karen Reed supporters have mixed emotion. You can definitely feel the tension, the anxiety as they've been waiting for days for the verdict to be announced, only for this to end in a mistrial. A lot of people are still here, still chanting, and still want to see what the outcome will be after all of this. But again, a lot of mixed emotions from both camps after this mistrial was declared. For now, live in Dedham, Tammy Mutasa, WBZ News. Back to you guys.
Tammy, thank you. And at this hour, still a lot of questions, still a lot of feelings, still a lot that is unresolved. If you're just tuning in, Judge Beverly Cannoni declaring this a mistrial after the jury was just unable to come to a unanimous decision. She does, you know, thank them for truly trying and truly putting time into deliberation. They were still deeply divided.
They were deeply divided, and you know, from basically the get-go. I mean, they had only been deliberating for a very short time when they came out and said that they were having some serious problems coming to some kind of resolution in this case. You know, she instructed them then to go back and continue to deliberate. Let them take she even asked them to take the weekend and said, don't talk about it, don't do anything, just come back fresh and keep an open mind. And even today gave them another instruction, trying to push them a little more. It's a controversial jury instruction too, because there are several states that do not allow what's called the dynamite charge, trying to dislodge a hung jury, because sometimes people believe that by doing that you will feel coerced, like someone who is a lone holdout will feel pressured to make a decision and to go against their convictions. So that's why it's controversial. But in this case, it also didn't work. It didn't move anyone who was, you know, steeped into what their own beliefs and convictions were in this case.
And right now we do have a team on the ground that is talking to supporters, giving you a lay of the land. We actually want to let you hear from one of the supporters outside of the courthouse. Let's listen.
How do I feel? You know, I feel that there was significant evidence by the defense that showed that Karen Reed did not kill John O'Keefe. Karen Reed was framed, pure and simple. Karen Reed was framed. A first grader could tell you Karen Reed was framed. And we have people from the Department of Justice, the FBI, and the military, the two experts that the defense put on. They are utilized by the United States government. And if those credentials and that testimony didn't surpass the testimony of this Mass State Police Paul guy who has an associate's degree in criminology. I mean, give me a break. You know, these experts were from the government. And so we need to learn from this. We need to learn what went wrong. How is it that these 12 jurors could not agree on the scientific evidence that showed Karen Reed did not kill John O'Keefe? And if we have juries, listen, we have learned from this case. We have serious checks and balances throughout the system that failed in this. And maybe we don't have the checks and balances. We need to get the checks and balances into the system. We need to transform our government, transform our law enforcement, and bring them up to the standards of the private sector. And now I believe that includes the jury too. Because if we have juries who do not understand forensic evidence in the 21st century, they should not be sitting on a trial. So
Now, what you just heard from there, that's Rita Lombardi. She's one of the Karen Reed supporters. Again, you can see emotions still very high. She was very passionate about what she was saying. But Cheryl, we do want to point out, we haven't heard from any of the supporters just yet, those who were there in support of the family, because in recent days, we did notice that they were also there to kind of counter what the Karen Reed supporters were saying. And they, again, out there in recent days. We haven't heard from them yet.
No, we have not heard from them yet. And we haven't heard from, the O'Keefe family, and we haven't heard from the prosecution, other than we did get that email saying that they do plan to retry her.
Now, right now, we do want to get you back out to WBZ's Christina Rex. She is outside of the courthouse in Dedham right now. Christina.
Yeah, Courtney, that statement from the Norfolk County DA's office, which you've read on the air, I would just love to read it again one more time. We didn't even know we'd be hearing from them this quickly. So they said a mistrial has been declared in the matter of Commonwealth versus Karen Reed. Judge Beverly Canoni set a status conference for a date of July 22nd at 2 p.m. in Norfolk Superior Court, this location. First, we want to thank the O'Keefe family for their commitment and dedication to this long process. They maintained sight of the true core of this case to find justice for John O'Keefe. The Commonwealth intends to retry the case. As early as 1 p.m. this afternoon, we were in contact with representatives from the Norfolk County DA's office asking if they've thought about whether or not they plan to retry this case, if they think they're going to be releasing a statement if there is a mistrial declared. And they didn't know, or that we were told that they didn't know yet. So to already have that statement saying, not only do we want to thank the O'Keefe family and have a response to the mistrial being declared here, but they do intend to retry this case. It's certainly interesting. And also incredibly interesting is the note from the jury. There's been 3 notes from the jury over the course of deliberations saying that they're deadlocked. This last one saying that they're at an impasse. And those notes signifying that some members were the term, some members of the jury just feel polarizingly opposite about the facts of this case. I spoke with our legal analyst who we talk to all the time about this case, Jennifer Roman, 3 business days ago, I think it was on Thursday. And she said to me, she had been worried from the beginning that this could be a hung jury. And I said, why? And she said, well, you go to a dinner party with 10 friends and you bring up this case and you can have 3 or 4 people who feel one thing, 5 or 6 people who feel another, and who cannot convince each other to feel otherwise. And she said, our jurors are a reflection of our community. This is a jury handpicked from Norfolk County. They live in this area. And she, Jennifer Roman, I'm speaking about our legal analyst, was not surprised at all to hear that they have fundamental disagreements about some of the facts and in this case and whether or not the Commonwealth has proved it beyond a reasonable doubt. And I said this earlier when I spoke with both of you, but I really can't overstate just how different today feels, and honestly, the last 5 days of deliberations, but particularly today compared to the rest of this trial. The heaviness in that courtroom was potent. To come outside in the rain, to have no, interviews with anyone involved in the case, just quick statements and everybody rush out of here. And in that courtroom, the 2 sides that you were hearing could not have been more different. As the judge said, I'm declaring a mistrial. You heard a sigh in the courtroom, not a sigh of relief, like a sigh. And you saw Mrs. O'Keefe crying. You saw other members of the O'Keefe family crying. And then through the windows outside, you heard cheers. You heard just loud yelling, wooing, which we've been able to hear many times over the course of this whole trial, because the courtroom is right on the corner of the courthouse. So whenever there's been a siren or cheers from the group outside, even though they're past some 200-foot buffer zone, those cheers you can hear inside that courtroom. So to have those two sides happen as a mistrial was declared, just can't really overstate how it was. Cheryl and Courtney?
WBZ's Christina Rex, thank you. And I think that she pointed out two interesting things. One, that we weren't expecting to hear from the DA's office this quickly. And I think that gives good perspective to our viewers who are not necessarily a part of the legal world. Maybe they haven't been following the case this entire time, so they don't know that we weren't necessarily expecting to hear from the DA's office. But also, she's letting us know that how different today feels. The feeling has been such an important part of the storytelling for our viewers.
Well, but I think that's normal. I mean, when you get to the point where a jury is deliberating, that's when it becomes really real. I mean, while the testimony is going on, it's part of the process. And now you get to the end of the process, and there's a lot riding on this. Her freedom, Karen Reed's freedom is riding on this. John O'Keefe's family wants justice, and they believe justice is a guilty verdict in this case. So you can understand the pressure that everybody is feeling. You can also understand the weight of all of that and the responsibility that these jurors feel to come to a decision.
Guys, if you can hear me take our live shot, the O'Keefes are going to leave court.
Now, I do know that we are working on, we are talking to our crew in the field right now. We want to get you back out to the courtroom. We are being told that the O'Keefe family is coming out of court now. So let's just wait a moment. But while we are waiting, this is, again, just a reminder that this is not over. This is not over for the O'Keefe family. It's not over for the Reed family, friends, supporters.
And you can imagine, I mean, this is, you saw the emotion. We showed you the video inside the courtroom. The O'Keefe family, very emotional about the mistrial. The Karen Reed's family, very emotional about the mistrial. And also knowing that there's still another process that they all have to go through again. So no, this is not the end for anyone in this case.
Nope, it's not.
You can see them filing down the courthouse stairs right there with family. Difficult day all around. I mean, at the end of the day, someone died here, so it's very sad.
Now we do have Christina Rex.
Cheryl and Courtney, if you can hear me.
Yes.
It's Christina Rex out here, next to the camera right now. We wanted to make sure you could see the O'Keefe family. Clearly, they waited inside to let a little bit of time pass. But some of the people who have been here every day were the ones in the courtroom. That's Paul O'Keefe, John's youngest brother, the only living O'Keefe child in this family now, after John's sister passed of cancer about 10 years ago as well. His wife, Erin, has been here every single day. His mother, John's mother, Peggy O'Keefe, has been here every single day. His father, John O'Keefe, has been here many days. I did not see him with the group here today. Some good friends of his, some cousins, some other relatives have been here every day. Really a pretty emotional moment for them in the courtroom. And then you could just see them there leaving court. It's clearly a sad day for everybody here on all sides.
Absolutely. At this point, you said that the family was very emotional today. Had you seen that type of emotion during the course of the trial at all?
Yeah, so I would say pretty much only from John's mother. John's mother, Peggy O'Keefe, has cried many times over the course of the trial, really mostly silently to herself. She puts her head down and cries during some emotional moments during the trial. His sister-in-law as well, a few moments, and another relative as well. But his brother Paul has really stayed pretty much somber, stone-faced over the course of this whole trial. You haven't seen much of a reaction out of him. He was the first person to testify in this trial, and he did choke up when testifying. I distinctly remember he was asked, "How many siblings do you have?" And when he was asked that question, he started to choke up because, as I mentioned, he had a sister named Kristen who passed away from cancer about a decade ago, and then he lost his brother John in this incident, of course, 2.5 years ago. And so he's the only living O'Keefe sibling. And when he testified to that, he got choked up in court. Otherwise, you haven't seen too much emotion out of him in the courtroom. This family is really kept to themselves, and, you know, incredibly kind and friendly in the hallways of court. But they've made a conscious effort to stay private over the course leading up to this trial and throughout this entire trial. And now who knows if that will change now that there's no verdict.
And you said that there was also a very sharp difference in the way that the defense and Karen Reed has been since the jury started deliberating. You noticed a big change in the way that they've responded with the media and outside the courtroom.
Absolutely. So in particular, there was almost a climax of that relationship on the day of closings, which was Tuesday of last week, if I remember correctly. So after closing arguments, when something changed out here, there were hundreds of more Free Karen Reed supporters outside of the courthouse. Many national media organizations showed up. So the amount of media covering this trial doubled or tripled that day, seemingly out of nowhere. And so that typical kind of exit interview that we did with Karen Reed and her attorneys every day when they walked out of court became wild on that day. There were way more people there than usual. And so as we made our way out of the courthouse, actually, Chris, can we show them where we usually go? Do you mind? So pretty much every day, I'm gonna have my photographer, Chris, show you, we would come down those stairs, leaving the courtroom, and Karen Reed's team, they would take a left, so going in the direction to your right, and walk towards their car, which is quite a walk, and we would interview them. That stopped as soon as the jury was deliberating. The mood was more somber, less questions, fewer interviews, very different. And for now, I'm gonna send it back to you both.
WBC's Christina Rex, live outside of the Dedham Courthouse. Thank you. And we do want to make sure you know, if you're just tuning in, Judge Cannone has declared this a mistrial. We will continue to have coverage for you, so stay with us. But we are going to continue this on CBS News Boston, so on our streaming app.
Right, and as the prosecution has already said that they do plan to retry her, and a judge has set a hearing for late July. So this case will be continued.
Thank you. Be seated. Closing session.
22117 Commonwealth versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in.
What does impact mean?
Please rise to the jury. Closing session. Please be seated.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannone, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please. Thank you. Be seated. Closed session.
All right, I'd like to pick a status date to find out what our next move is. So I'd like to come back sometime maybe the end of July. I understand people have vacation schedules. Can we come in the week of the 21st?
That's fine.
3 weeks.
No, I'm just looking at my calendar. Could we do the 22nd at 2 p.m. Ron? And I would appear for my client.
All right, is there another day that week? Could you do the 25th or 26th?
Unfortunately, I think I'm supposed to be for vacation on the 25th.
Okay, the 22nd and the 24th are not great dates. So
Okay. What about the 19th and 9th? Is that whole week?
no, that week's not good. Teaching that I cannot get out of.
Can we do August 7th, 8th, 9th? Any of those days?
No, we'll do the 22nd. We'll go back to the 22nd at 2. I can't let it go that long.
Your Honor, so for those, Ms. Lulu and I are not available on the 22nd. We have a hearing in Los Angeles on the 22nd.
Okay.
We're proposing to appear remotely anyway.
Okay.
But for a status conference, I don't want the court to think it's disrespectful to the court, but Ms. Lulu and I probably will not.
Okay. So you and your client will be here in person, Ms. Giannetti.
Yes.
All right. All right. Thank you. We'll see you then.
Football rise.
Wow.
In the court, so I think it's important that Karen is not only freed, but that we find what really happened. I think that's justice for John O'Keefe. But I understand different people have different opinions, and I think everybody's respectful of that. But this is how I show my through my art is how I sort of show my work and my thought about it. Yeah.
So then I guess going off of that, how would you feel if the jury did come back and they were still hung and you didn't get that answer you've been looking for?
I'm hoping that they'll investigate it further regardless. And I would like to believe that the Commonwealth wouldn't retry the case based on the way this went. I think that they had a poor case and the defense proved that. So, I mean, obviously we want to not guilty, but I guess if it's hung, I'll just hope they don't retry her, that they can see the flaw in the indictment, original indictment.
Is there anything else you want to add? Any details?
No, just free Karen Reed, and that's it. Yeah, and you can use art to portray your feelings and make statements with that. I like the idea of people using their art for good and for causes.
Sweet.
Yeah.
Well, thank you so much.
Thank
I really
you.
appreciate it.
Thank you so much. Just ignoring them.
Yep, I agree, John B. Yep, hopefully there's not another hung jury. Because if it is, that's gonna be hilarious. You know.
Move on with myself? That makes no sense. We all have the right to be here, Sam.
Does not mean I would want a innocent woman going to prison. Thank you, thank you. Thank you, guys.
I realized that this was just a big propaganda campaign.
How do you feel about opinion because you used to be on the other side? You guys are out here today, bigger than
Support John. So hopefully a lot more people. And that's why she took so far. If I wasn't my own boss, I wouldn't be here today because I knew they were trying to get me fired.
And going
And
back
people
to
have been fired because of people like you.
and going back to comments online, I mean, what do you make of people saying some of the mean things that
You just
are
have to
being
have
said?
thick skin, and I ignore it because I know it's irrelevant and it's not true. And if you don't give it attention, then it's less relevant.
And you're firm enough in your belief that you're willing to come out here despite maybe being
100%.
harassed or
Yes.
people say that you guys are more anti-Turtle Boy than you are, I guess, anti-Karen Reed.
You know, for a long time, I believed she was innocent and I didn't support him. Okay. And then over time, I looked further into the evidence and I realized, oh my God, she did it. So for a long time, and that's just a way to deflect. It's not true.
So would you say you're here to be anti-Turtle Boy, anti-Karen Reed,
This
or
has
both?
nothing to do with Turtle Boy right now. This is all about Karen.
So she can't be on the jury if she.
We're back. We have the final result for the Karen Reed trial, at least round one of it. We're going to watch the judge announce what the jury said and what her decision is. We're going to talk about what happens next and what the time frame is of what happens next. We're also going to watch a short clip of an interview done on the courthouse steps by Karen Reed and her defense team. And people are asking the question, all of you guys are, will this defense team be back round two? Who has the advantage trying this case again? When will the Commonwealth announce whether or not they're going to try Karen Reed again? Did it already happen? Let's talk about all that and get to your questions on today's video number 2.
This is the lawyer we know.
All right, so we are going to start with what the judge says in reaction to the most recent jury question, or as I like to call it, jury comment, because the jury came back before the end of the day. It really is not that surprising. Again, it's not like a mind reader or a fortune teller or a savant of any sort to figure out that once 12 people start to dig in on what their belief is, what their vote is, what they're going to do on something as serious as this, that they've clearly taken their time to think about, honestly, it's not that surprising that they don't want to change their mind, regardless of what a judge says, regardless of what anybody says, because at the beginning of the case, they were ordered to. Hold on a second. Okay, hold on. Just time out. I have to text John. I mean, delete the stuff that is saved in our banners that I've been, or the banner stuff that's been in there for days. That's hard to scroll through. Okay. So anyways, so we've gotten to a point where I wasn't surprised that they didn't go back on what they already thought and what they already felt, because they had looked at all the evidence, they had thought through everything, and they came to an informed decision, and they weren't going to change their minds. So let's listen to how it panned out in court today.
Commonwealth versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in.
You guys to the jury. Court of the session, please be seated.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges.
Did you notice the verbiage that she used and the words that she used? It's very important to see and hear exactly what the jury foreman said about who, or more importantly, how many people are on each side of this issue. So let's listen to it again and listen to whether they say a juror or jurors.
Receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions.
So multiple people, which I think they've already kind of led us to believe on the last comment that they made, but multiple people on this jury are on each side of the aisle when it comes to guilty or not guilty. And their deeply held moral beliefs will not let them change course. And people's deeply held moral beliefs and convictions are what they live their life by. It's their worldview. It's how they make all their decisions for the most part, for some people that have that. So it's very hard to change that. And I think they have continuously indicated to this judge that they've tried, and it's just not going to happen. And like I said, because of how they've already indicated that in the past, and now they've indicated it multiple times to this judge, it's very hard for her to send them back again, even though technically maybe she could. Maybe the appellate court would already look at it and say, you already sent them back twice, so that's it. But we're at the point where I think she knows it's over. So why create another appellate issue by sending them back again? Why make them come back tomorrow? It's over.
To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All right, so the court, please.
So
Yeah, no
she's
choice.
releasing the jury. We are going to watch them kind of walk out of the courtroom here. But the interesting thing is she said she was going to go speak with them privately. And I know a lot of you guys have questions as to, can this jury talk about what the split was, what the vote was? They're usually told, and I've heard in Massachusetts, it's even more so, don't talk about other jurors. Don't talk about where they are. If you want to talk about your experience, you can. Don't talk about votes or how the split was or anything you talk about in deliberation. So I did hear that that is strongly discouraged. I wonder if that's what she goes and does behind closed doors with this jury. So we don't know what that conversation is or was, but you better believe people are going to be asking them for comment. And if you guys see them, tag me in them, send them to me. I really want to hear what this jury has to say about how these deliberations went. I think it's going to be interesting. I don't think there's going to be a lot of hate thrown like the YNW Melly case. Maybe there will be. I don't know. This case has been pretty divisive, but if there were multiple jurors on both sides, that's very different than one holdout. So let's watch the exit because a lot of people had things to say about, people leaving the courtroom. So we'll just watch it here.
Thank you. Be seated. Court still in session.
All right. I'd like to pick a status date to find out what our next.
Oh, I forgot. We get to do this first, which is important. And we're going to look through the Massachusetts criminal rule to try to determine when they have to get this trial done by, this retrial.
Move is. So I'd like to come back sometime, maybe the end of July. I understand people have vacation schedules.
It's fair. It's vacation schedule is not a bad thing. I know people always, say, oh, lawyers, of course, they got to go on their vacation. They probably have a tea time. Sometimes it's true. But they've been trying this case for weeks and weeks and weeks, working on it for weeks and weeks and weeks, even months before the trial started, getting ready for trial. They're going to have to do it all over again. They deserve a break. And so, it is what it is. She's going to try to set it as quickly as she can.
I'm in the week of the 21st.
That's fine.
So this is interesting. She gives the week of the 21st, and this is brutally sad. For John O'Keefe's family, no answers, no ending. It's going to keep going. It's sad for Karen Reed, too. No ending, still hanging over their head, no finality. That's why a hung jury is always brutal. A hung jury is literally always brutal for basically everybody involved. All the work, all the energy, all the effort. But usually, the defense can look at it as they couldn't prove guilt beyond a reasonable doubt unanimously, which is what's necessary to convict. Usually, it's can be more of a glass half full for the defense than it can for the Commonwealth. There's basically no winning a hung jury decision if you're the Commonwealth. Now, some could see this case as they thought they were going to lose, and they didn't technically lose. So you could try to look at that as a glass half full, but they got to do it all over again, too. Taxpayers' time, taxpayers' money.
Yep, it was expensive.
No, I'm just looking at my calendar. Could we do the 22nd at 2 p.m. Ron?
So she asks him for the week of July 21st. And I found this exchange to be interesting, right? She picks the week of the 21st. Yannetti gives her the 22nd. And just listen.
And I would hear from my client.
Is there another day that week? Could you do the 25th or 26th?
So she doesn't like the 22nd. He also started to say, I will be there, but it sounds like Jackson and Little will not be there, which adds intrigue to some of the questions about the future.
Unfortunately, I think I'm supposed to be for vacation on the 25th.
Okay, the 22nd and the 24th are not great dates. So
What about the 19th and 9th? Is that whole week?
no, that week's not good. Teaching that I cannot get out of.
Can you do August 7th, 8th, 9th? Any of those days?
No, we'll do the 20.
I mean, he's given her a ton of dates, and she's like, I can't do that day. I can't do that day. The days she can do, he can't do. So he tries to push it out a week. She said, I don't want to wait that long. And she's right. We need to turn this around quick, figure out who's going to do what so everybody can start preparing so we can pick another trial date.
22nd. We'll go back to the 22nd at 2. I can't let it go that long.
Your Honor, so for those, Ms. Lula and I are not available on the 22nd. We have a hearing in Los Angeles on the 22nd.
Okay.
Proposing to appear remotely anyway.
Okay.
They have a hearing in Los Angeles on the 22nd.
For a status conference, I don't want the court to think it's disrespectful to the court, but we will not.
Okay. So you and your client will be here in person, Ms. Giannetti. All right. All right. Thank you. We'll see you then.
So Jen, when we say moral beliefs, sometimes it comes down to morally, I think it's wrong to convict somebody even though I have a reasonable doubt. Some people will couch it in that, right? Like, even though I think she did it, I have a reasonable doubt, or the Commonwealth didn't prove it beyond a reasonable doubt, or those experts created some doubt in my mind, so I can't vote guilty. That could be defined as a moral conviction from some people. It could be. So, I mean, it all gets mixed up, but at the end of the day, the jury wants to do what's right. And we say that what's right is following the facts and the law. And at the end of the day, they still have to vote with conviction and with what they think happened and what they think is right and what they think the right decision and vote is in this case. So I think it's not like them saying I'm voting on feelings instead of facts. I don't take it to be that at all personally. All right, so now comes the exit of the courtroom where a lot of people had a lot of things to say about what went down here.
Football rise.
So first off, I want to point out the look on everybody on the defense team's face basically definitely indicates to me, I don't know if I'll say they're happy with this result, but I think they're satisfied and they're taking it as a win. And there's a lot of hugs and handshakes and good jobs and, things that you wouldn't expect to see if they were really, really bummed about what happened in this case. So I do think that that's worth pointing out and worth noting. A lot of hugs, a lot of handshakes. So there was a little exchange between O'Keefe's brother and Karen Reed as he walked out. I don't know what he said, but more importantly, I think if you look at this defense team and we're trying to figure out who thinks what, who did what, who's happy with the result, who's mad with the result, it does seem to me like the defense team is a lot more satisfied with this result, even some smiles on their side, some good jobs, some pointing, some thumbs up, to where I do think that they are at least okay with this result. And I'm just basing that off of what they're doing here on the way out. Thanking people in the courtroom, things like that. Okay, so I found that to be interesting. I'm going to answer a couple questions here, and then we are going to get to when do they have to retry Karen Reed if they decide to do so. Do we know what the split was yet? No. And we might not. Matt, how can witnesses' own testimony be used in the retrial? So they can kind of change it, kind of edit it, and they can be impeached with their prior trial testimony if they change anything major. They can be called a liar, basically, if they change their testimony. You can add questions like, it didn't make sense when you said it before, did it? If they change it to make it make more sense. Not that I have any specific witnesses in mind. Mike, the last jury note was interesting. Leaning with the guilty side. I think a note would start with the opinion of the majority first. Could be wrong. I don't think I've seen some reaches in this case and some people really trying to read into things. I think that's possible. I think it was probably more split than we expect, even if we don't know what the exact split was or which side even was in the majority. Can parties use new experts at retrial? Potentially. If the court thinks it's fair, thinks it's unfair, they might not. But you can bring some reasonable, new, or different stuff in, as long as it doesn't violate any rules. It doesn't violate any unfair discovery, especially the defense. If they find something that they believe is exculpatory between now and the next trial, it's absolutely coming in. And the Commonwealth can add people to their witness list that were already in the investigation that they decided not to call the first time. They can call them the second time, and vice versa. They don't have to call every witness they called this time and, pray that they don't. But they don't have to call all the same witnesses. If any juror believes in the defense, they could be very helpful to them as they prepare for round two. Absolutely. Could provide what the sticking points were. Evidence won't change. Retrial benefits defense, in my opinion. So we'll talk about that a little bit more, who it benefits. But what's interesting about this is every juror is very different too. Every juror is very different. So a new set of jurors is going to create a new set of issues, but you could definitely learn a lot by talking to the jurors. Michelle, I don't know if she's guilty or not, but I do know the Commonwealth didn't prove it. To me as a juror, as I would have held my ground to, thank you for all you do, Peter. I've been following you since Depp. That's awesome. Why would the Commonwealth want to go through all this again with the awful investigation, text messages, and butt dials and everything? The world is watching in shock and horror. So what I would say is they probably want to do this again because the defense accused law enforcement, the Commonwealth, the prosecutors, everybody involved basically in being in on this cover up and prosecuting somebody wrongfully who they know is innocent. So they don't usually take kindly to that, and it's not a surprise for them to want to come at the defense and keep going on this. Can you react to Channel 4 UK, the jury murder trial? So I don't know what that is. I'll have to take a look at it and see if it's something that, maybe I can add some value to. But I did want to put this tweet up here real quick. Forget it. I don't need to put the tweet up. So NBC 10 Boston is reporting officially that the Commonwealth has decided they are going to retry Karen Reed. So they are going to do it. That's something that would probably be announced at the July 22nd hearing that they're going to have. Maybe they'll pick a trial date. We're about to look at the criminal rule to see when that time period is. Amy, can the FBI stop a retrial? It's not necessarily if they have to step in and stop it, but what they find or what they determine or what they do if they indict some people, that could definitely have an effect on it and whether or not it goes forward. How do judges feel about a hung jury? Is it a blemish for them or does it not really matter? I don't necessarily think it's a blemish on them. They don't love it. They feel like it's a waste of time and resources. They try not to make it happen. It's not really their fault unless they really limited the lawyers on jury selection and didn't let them strike people that they could have foreseen would become a problem. Diane, when the judge said she would be back to speak to them, can she ask them why no verdict? Can new evidence be brought into a new trial? So potentially new evidence can. And I don't think she's asking them what their verdict is. I think she's explaining to them what their rights are, thanking them, telling them they don't have to talk to the news, maybe cautioning them about, how this could be problematic or to let her know if anybody harasses them, things like that. Sindhu, what if for whatever reason there's a hung jury again in the retrial? Does it just keep going to a jury has a verdict? When does it stop? Yes, potentially it can just keep on going if the prosecutor decides to keep retrying Karen Reed, unless something happens where the judge eventually throws it out. But at this point, for everybody that said the judge was so biased and horrible for not throwing the case out, and again, I feel like the prosecutors did not prove it up, and I would not prosecute this case based on what I know and the evidence presented. But this is where the bar is as far as a reasonable juror voting guilty. So the judge, if she would have thrown it out and said, I'm dismissing these charges, I am granting a judgment of acquittal because I find that no reasonable juror could find guilty in this case. It means one of two things. Either she was just dead wrong because there were jurors that were voting guilty on this jury, or number two, she would have been saying the jurors on this jury that voted guilty are not reasonable jurors. I wonder if there would be a better outcome after the federal investigation concludes. It seemed like both sides wanted to continue this case. Why? I don't know. Maybe they want to see what the federal investigation was going to show. Joe, could Norfolk County residents file a petition to their Congress people to talk to the DA about not prosecuting this again? The DA is for the people, right? Yeah, but I don't think they want to get in. This is, separation of powers. This is the district attorney or the Commonwealth's decision. And they don't want to create a habit of stepping over the line. What if the next jury would be split too? Then they would just have another mistrial and potentially try it again. Peter, is this typical of a judge to privately speak to jurors on high-profile cases? Seems sus if she's going to be the judge at the retrial. Thoughts? I wouldn't like it. I would hope it's transcribed or there's a court reporter in there. I would like to know what she says to this jury, but overall, it's not going to affect the next jury because none of these jurors are going to be witnesses or jurors on the next case. I meant a jury, not a guilty. Autocorrect on Super Chats. I don't know why. It seems like it's extra bad on Super Chats. T. Shaw, now Lally can change his timeline in a new trial. Well, I hope he doesn't say 12:45 again in opening. That would be an easy fix. If they go to trial again, another hung jury, would that be case dismissed or can they do round 3? They can do round 3. It seems like that's a common question. They can do round 3. Is there going to be a gag order for the jury before the retrial is done? I don't know, Azam. We're going to have to wait and see what comes out about that because I don't know the answer. Told her I'm not done with you yet. That's what people are saying. Interesting. What do you think the defense and prosecution should do differently in the retrial? There's a lot. I mean, for the defense, it would focus on reasonable doubt more than proving the conspiracy. I would also file motions to limit a lot of the testimony from all the cops. Like, I wouldn't let all these cops be testifying to medical stuff or accident recon stuff. I would also put Trooper Paul through a Daubert hearing like the prosecutors did with the defense experts. I don't think he can testify to any of that stuff. He doesn't have the right backing, information, mathematics, physics, equations, evidence. There's no way he should be able to testify to that. And if he does, they should be locked into that. They can't argue 7 different ways that this happened. The Commonwealth is not the defense. And so I would do some stuff pre-trial differently than they did in this case. And for the Commonwealth, I would get my timeline straight. I would make sure I would build a timeline at the beginning of the case, put all the witness testimony in it, put where I believe this happened, put that the accident actually happened at that time, 12:32 or whatever. Ask Jen McCabe, and she was like, maybe she says 12:30 to 12:45 instead of 12:45, whatever it may be. Don't ask people to lie, but I'm saying if she could be off by her 15 minutes, then clarify that. They're going to impeach her, though, and make her look like a liar, and you've just got to figure out, what are you going to do? Because you can't change bad facts, right? You can't change bad facts, but you can change putting the wrong time in your opening statement. Is there enough time for Proctor to get convicted of a crime prior to testimony in a new trial? Wouldn't that be worse for the Commonwealth? There is enough time. That would be worse. I don't know that that's necessarily going to happen. Adam, I hope the FBI investigation brings some light. I do too. Kelly, to be part of this professional group, OBX bound, lawyer Cap, on the beach. Thank you and congrats. Oh, I'm a little jealous. Grumple, will the judge change? Unlikely. It's possible, but unlikely. Lady Page, they're coming back later this month for a status conference. Can you please explain that process? So they come, they say, are you going to retry her? Let's try to get a trial date on the books. It's definitely got to be within the speedy trial period, which we're going to talk about here in a second. And the judge has got to give more deadlines when stuff's going to be due. They've got to go through everybody's calendar again, all these different lawyers, all these witnesses, experts. When are they going to be available? Is there anything we need to clean up? Any Daubert hearings or things we need to have? So there's a lot that might have to be done in a short period of time. What are your thoughts on when we hear from the FBI? We may never, right? They may just close the investigation, or they may have indictments. I don't know. Will she even get a fair trial second time around? This is being followed all over. So Joanne, that is a major issue. Where are they going to find a jury that doesn't know what happened in this case already, isn't already watching the first case, and hasn't already made up their mind? Because all of us, including myself, that didn't know anything about this case, I would now not be able to sit on this jury where I would have been on the first time around. Can Karen still sue the Commonwealth despite a mistrial? Be very, very hard to win. Very hard to win. Because the lawsuits would suppose a cover-up, a prosecutorial misconduct by law enforcement. And at this point, multiple people thought she was guilty of this crime. At the very least, we have, some kind of ancillary circumstantial evidence of that. I like tacos just to bring some happiness. Oh, yummy. And if they don't reach a verdict the next trial, they do it again. Do you think Lally was allowed in when the judge was going to talk to the jury after everyone left? I sure hope not, or we have a YSL situation. By the way, Glanville did not recuse himself, but I'm going to hold. Me and my dad are going to do a video breaking that down later. Danny B, hi, Peter. Wild turnout. It'll be fascinating to see how different the new trial can be or will be. Can you do an analysis on the Supreme Court ruling on presidential immunity? Ideally, a before and after. Would love an objective take. Again, Danny, if people are interested in this, let me know. And if they are, I'll dig in. I'll take a look at it and we'll break it down. But that's how I pick all the content on our channel. Recline. How will they find a jury that hasn't heard about this case and be truthful? The world was watching. And that's the big part is, will they admit how much they know about this case? Jessica, do you think the defense's strategy will be the same in a retrial cover-up / conspiracy versus just proving reasonable doubt? I don't think it's that big of a change, right? It's just a little addition on there. Like, you don't have to believe our theory. They clearly didn't prove their case, but you can still put forth your theory or give the jury a theory of what you believe happened. I would just focus a little bit more on reasonable doubt, which I hope they do. But again, they know the case better. They are better equipped to do this than anybody. How do we find a neutral jury second time around? You guys are all on the same page, and I'm right there with you. Does no new evidence rule in new trial apply equally to the defense and Commonwealth? So, like brand new out of left field evidence, if they were to say like, hey, we found another taillight piece, or we've done some testing, it's possible it could come in. The defense could object, or if the defense brings something new in, the Commonwealth can object. And in the interest of justice, should it come in, should it not? Fundamental fairness would come in, weighing a fair trial to the defendant, weighing a fair trial to the Commonwealth. So it is possible certain new things or different ways of saying the same thing could come up. It doesn't necessarily have to be exactly the same. They don't have to call the same witnesses or the same order. They don't have to put in all the same exhibits. So it doesn't have to be exactly the same trial, but usually they are pretty similar when there is a retrial, and there's not a huge time period between trial number 1 and trial number 2. Commonwealth can call new witnesses in a retrial. Potentially, yes, especially if there are witnesses that were already there or mentioned, or if they figure out, who those unnamed people were that came and searched the house. Potentially, they may call them or tell the judge, we need to call these witnesses to fill this hole. So it is possible, but it's not just going to be a completely different case in a different trial. Who the heck is there left to call? It's a good point. I think me, lawyer, and my kids' cats are the only ones who didn't testify. They definitely called a lot. If the judge polls the jury, will the Commonwealth and defense be told? I don't think the judge is going to poll the jury outside their presence. I don't know that she can poll the jury that way. Becky, how are they going to find impartial jurors? I live in Washington State, and this trial is everywhere. It's going to be tough. Azam, Peter, can they ask for a different judge? They can't ask for a different judge, but they can ask for her to be removed, recused, or disqualify herself if they think it's necessary. Ashley, defense/FBI had the goods for not guilty. Thoughts on the DA already saying they'll retry her before finding out the jury breakdown shows they don't care about the facts? Honestly, I disagree with you there. I don't think it matters what the jury breakdown is. I think if they want to retry her, they think she's guilty, they think that's justice for the victim's family, that's their decision and within their discretion to retry her. I disagree with it. I wouldn't retry her. But what the jury breakdown or the jury vote in is at the end of the day doesn't have to be what the deciding factor is. And again, they may never find out what the breakdown is. They may, but they may never find out what the breakdown is. So it's not unusual that that's not the deciding factor. Can Chloe the dog be subpoenaed at the next trial? Maybe they will find her. Maybe they will. I don't know. That's interesting. Because if the witnesses or the Commonwealth was blocking that and now it's available, I think that's fair game. Alicia Joe, just picking up on the point you just made, are the defense able to limit some of the prosecution testimony, or is that up to the judge? The defense can request it. Ultimately, of course, it's up to the judge. And they may have already done this again because I didn't follow the pretrial stuff. I'll follow it now. If we have hearings and stuff now that I'm already in on this case, I will absolutely be following it. But I would absolutely file additional motions if I was them. Justin, can the defense use the trial testimony to hold the same witnesses accountable to the next trial like they did with the grand jury? Yes. Doesn't mean the testimony, as you saw with the grand jury testimony, might not be a little bit different, but they can impeach him with that prior testimony. Do you think Occam's razor would find her guilty? I don't even know how to answer that. Joe, how likely is it for Lally to practice his presentation skills, organizing his witnesses, and is not being redundant by the next trial? I think he'll probably have a similar demeanor and presentation, but maybe the way he does things and the way he puts up the witnesses in the order and the timeline, things like that might change. MD, he's pretty seasoned at this point. I don't think he's going to change his style. If the Commonwealth says different in a new trial, can it be used to perjure them if it's different from what they said in this trial? If they say that John was inside the house now and everybody says, oh yeah, he was sitting right next to me on the couch, then maybe perjury. But if it's around 12:45, it could have been a little bit sooner, and they impeach her with before you said 12:45, that's different than perjury. JD Ski. So why didn't they ask if the new John was coming to the house, or why, if the police and friends, why they worried or looking for their friend? I think they did ask some of that. It didn't come off perfectly, but they definitely asked some.
Give me 1 second.
Just me, does the jury keep the notes they wrote? No, not usually. Not usually. Peter, do you think there'll be a change of venue? I don't, because it's very unusual, but we'll see. Thank you, John. This will give me a second to bring up this rule of criminal procedure I want to look at real quick for us to discuss when a retrial could take place. All right, let's take a look at this. If a retrial of the defendant is ordered, and that's what I expect to happen in this hearing we have later in July, the trial shall commence. I mean, it must, it has to. You are forced to try this case within 1 year after the date the action occasioning the retrial becomes final. Okay, let's just stop there at that comma. So they have 1 year. So by next June or July, this case has to go to trial. And it has to commence, meaning start. It doesn't have to finish. So they don't have to start, 2 months, 10 months from now to finish it in 12 months. So that's a longer time period than most of the jurisdictions that I've had where this has come up. 1 year. What do you think about that timeline? Do you think it's too long, too short? Do you think it'll happen within 1 year? Because we're going to talk about some of the exceptions here in a minute. Beth B, can Karen sue Morrissey even though they're going to retry? It'd be really hard. It's not like a not guilty verdict. Chris McNamara, can they negotiate lesser charges like plead guilty to something with no jail time? Yes. So they can do that. They can do that. They can say maybe she pleads to DUI, first time DUI. She takes a course and it goes away and whatever. But they can absolutely negotiate at this point. Yobi, what color is your Tesla? White.
Over there.
Listen, M, does the Commonwealth have to stick with their theory of how he was hit by the car? If they change it, can the defense ask them on the stand why they changed it? Yes, especially Trooper Paul. Now, not a lot of people said exactly what Trooper Paul said with the hand extended out, but if he recreates the acts in a completely different way, they could say, you've already testified about this, right, sir? And this is how you said happened. But you change your testimony because physically it makes no sense. This breaks the laws of physics and mathematics for this to happen in this way with a 6'2", 220-pound guy, whatever. So yes, they can hammer it if he changes it. Bob Ross, how do you maintain confidence in the justice system when even defense expert says injuries were not typical of car pedestrian collision? Honestly, I trust the system because it's the best we have. And people have to look and see if people are being credible, if they trust people, hold people accountable. But we also deal with a world that people abuse their power. And it's hard sometimes for people to understand that or believe that it's true. And if it was good enough, I would have to believe the jury would have come back with a not guilty verdict outside of one person just already being stuck to their guns and stuck in their ways. And the jury selection process did not find them out to strike them before they got there. So again, it's not perfect. I've never said it's perfect, but it's the best that we have, in my opinion. Lauren, if the FBI investigation finds wrongdoing, how does that affect the retrial? Well, they could have some people that are indicted. They could have some findings by the FBI, potentially, some reasons for those findings that could potentially become relevant in this case. Would the FBI be able to close the case down if the people involved in the case are all under investigation? So not just being under investigation, but if a bunch of people get convicted of covering this up and fraudulently dealing with evidence and manufacturing evidence and tampering with evidence, then yes, the case would go away. Paul O said, I'm not done with you yet. Judge has a lot of mistrials, now doing civil cases. Her sustaining a lot of prosecution objections, keeping evidence out made it harder for the jurors. I think that's an opinion. Let's limit all the witnesses lying, fake experts, incompetence, and lying, and the corrupted evidence gathered. Just those few minor things. Might be a short trial, Daria. According to Twitter, Paul O'Keefe said, I'm not done with you yet to Karen Reed. Who you with? I'm not sure what this says. Jason B. The O'Keefes are sad now based on a mistrial, but imagine if Karen Reed was found guilty only to later learn it was the McAlberts insult to injury. Yeah, I mean, there's no great result for them, in my opinion. Okay, let's take a look at this again for a second. So as extended, again, the 1 year can be extended by subdivision B2 of this rule. Okay, and B2, where is it? I found it before. Basically, here's the point. If calendars and scheduling occur where basically the defense is okay extending this, the Commonwealth is okay extending this, the defendant waives her right to be tried within 1 year, there are issues that could extend it past the 1 year. But if Karen Reed says, absolutely not, I want to be tried within a year, then that's going to happen, and that is her right outside very extenuating circumstances. Another reason why we don't really always want to wait a full year or the time limit in this case is it's fresh. We know it. We've just done it. If we push to a year, I just had a trial continued that I was picking a jury, mistrial happened, jury panel busted, and the judge kicked the trial to a year. Guess what? I have to redo basically everything I did to prepare for that trial. Months in the making, preparing witnesses and opening statements, closing arguments, jury selection, arguments to the judge, motions in limine. I have to recreate the wheel because it's a year later. If it would have just been 2 or 3 months, I could have just stayed on top of it, refreshed my memory. So we'll see what they do. And if it's a year out, that's brutal for all the lawyers involved. But you have other cases, other clients, and other things to do as well. So that's important as we talk through. Peter, please explain how this is not double jeopardy. I know there was no verdict, but the Commonwealth will now have a second bite at the apple, knowing what the defense has to offer. They can fix their stuff. Not fair. So this has been litigated back and forth, and the appellate courts and the Supreme Court have found that this is not double jeopardy. The only way I can explain it to you is that's their decision, and it was not guilty. They are definitely put in jeopardy twice, and the Commonwealth definitely didn't prove their case beyond a reasonable doubt unanimously. So I get why you'd have an issue with that, but them's the rules basically at this point. So who has an advantage the second time around? In my opinion, I already kind of mentioned before, the better lawyers. And I think objectively, I'm not saying Lally's a horrible lawyer, but objectively, I think the defense team was better litigants and better lawyers than the prosecution team. So I think advantage them, number one. Number two, I think they're going to be able to cut some of this stuff out pre-trial. Number three, they have the dog bite expert. Maybe they can fine tune her testimony a little bit. They know now what the ACA experts had to say. We get more time for the FBI investigation. Maybe they'll find more. Maybe they'll indict some people, right? So I think this benefits the defense more than it benefits the Commonwealth doing this again. That's my opinion. We'll see. Why would deeply held beliefs be relevant? It's about proof beyond a reasonable doubt. Only DHB should be following the law on innocent until proven guilty. If some people believe cops, that's a deeply held belief, and they've got to judge witness credibility, and we know that's an issue, and that could happen. Some people thinking, a deeply held belief that it's impossible for all these people to be involved in a conspiracy. Some people with deeply held belief that all cops ever do is screw people over. That is a filter in which the jury looks at facts and looks at the law. We might not agree with it, but sometimes it can affect the outcome. Peter, the biggest mistake was saying, I hit him. Give mine to Pops. So, yeah, I do think her words were a big part of this case. Macaw Mama, I know what it's like to be the wife of someone wrongfully convicted. Emotions are nothing you can explain. I feel awful, all parties hurting by this death, having to go through this again. I agree with you. Wow, it's past 4 a.m. already. Didn't sleep. Oof, Azam, it's going to be a long day. Allison, dig up the basement and pool, find the dog, match the unknown DNA on OJO's clothes, and get to the bottom of the Sally Port video. Yeah, I mean, stuff like that, the inverted video they can fix potentially some of their missteps through trial, but they can't fix Trooper Proctor. They can't fix Trooper Paul. They can't fix McCabe, Albert, all of those, butt dials and deleted stuff and different Google searches. Even though they have their evidence, that's all going to come out similarly, I think. Can AJ and or Lally have private meetings with the feds to garner new info, leads, etc., or do the feds have to go to them? They can ask them. We as defense lawyers can always ask them, and if they're going to bring us into secret meetings, great. Give us more insight, give us more information, give us things that are going to help our client, because at the end of the day, our main goal is to zealously represent our client. Our duty is to our client and to nobody else. And so if they're going to share information with us that's going to help our client, it's our job to get that information, period. So sorry, Peter was in a hurry earlier and misspoke regarding Glanville. Sent you an X comment, didn't recuse. He just agreed to transfer to another judge. Sounds like yes. So the other judge is going to be making the decision on his recusal, and we're going to break all that down in depth. Don't worry about it. I appreciate you letting me know stuff's happening. I feel like you are an auctioneer reading these super chats sometimes. If the defense believes and wants to know if any evidence was buried when the pool was suddenly filled in, what does that legal process look like? You have to file a motion for entry on land and to do destructive testing. The judge has to allow you. You have to have a good faith basis. It can't just be a fishing expedition. It's very difficult to do, but not impossible. Yeah. Brooke, do you think the next jury, knowing the previous jury couldn't come to an agreement, will make them presume reasonable doubt? So they won't know that unless they watched, obviously. It's not a fact that's going to come out in trial. But I think if they did find that out, they may be like, oh, crap, this is going to be harder than we thought. I don't know if it would make them presume reasonable doubt or make them think maybe we're not going to come to a verdict either. All right, let's take a second now to watch this clip on the courtroom steps.
I'm back.
Let's
see the bathroom
of Karen Reed and her attorneys and what they had to say about this case and about the outcome. Here we go.
Folks, this is what it looks like when you bring false charges against an innocent person. The Commonwealth did their worst. They brought the weight of the state based on spurious charges, based on compromised investigation and investigators and compromised witnesses. This is what it looks like. And guess what?
No.
They failed. They failed miserably, and they'll continue to fail.
So again, still preaching innocence, cooked up charges, forcing something that doesn't fit, and they failed, and they failed miserably because, again, a prosecutor's job is to convict. It's not, but you get what they're saying when they kind of leave that out there and saying they failed, and you can clearly say they failed because they were coming in here saying she did it. They have all the power. They have all the resources. They make the decision whether or not to charge. And guess what? They charged her. They said she was guilty beyond a reasonable doubt. They said they were going to be able to prove it, and they failed. Now, it's disregarding that they have publicly said, we're going to win. She's innocent. We're going to prove it. We're going to prove the conspiracy. Wait our turn. And again, I didn't think they needed to say all that because there's a ton of reasonable doubt. And I think they did an excellent job of pointing that out. But this is what it sounds like for a defense attorney to say a hung jury is a win. And this is what a lot of defense attorneys say. Now, I kind of expected them to win by the end of the trial, which is the only reason why it's a little bit different than most circumstances. It's a home run for a hung jury, or at least a triple for a hung jury for a defense attorney. I don't know that I felt that way in this case. You guys let me know if you disagree in the comments. He obviously is taking it as a win and a failure on their part.
No matter how long it takes, no matter how long they keep trying, we will not stop fighting. We have no quit. Go ahead.
We will not stop fighting no matter what they do. And we already know they're going to retry her, so they're going to keep fighting. They have no quit. Then I heard somebody say from the crowd, I don't know if you guys heard somebody say from the crowd, Alan, will you be staying on? And he lets Yannetti go in front of the mic and talk now. So that's a big question that's still open and more to come on that.
I just have two things to say, folks. Number one, I am in awe of the strength and courage of this remarkable client that I've had the privilege of representing since day one. And
you know, a little cheeky there that I think it's kind of a wink to the public watching, and he's not done. He's going to do a lot more than a wink to the public support for Karen Reed and how important it has been to this trial, which is interesting. And we're going to discuss this comment after.
Number two, I want to say client that I've had the privilege of representing since day one. And number two, I want to send a message to all of her supporters out there. Your support was invaluable. We are touched, and we ask for your continued support. I'm not from Texas, like my colleague here. I'm a Boston kid, but I'll repeat what he said, which is, we ain't got no quit.
So again, no answer to will Jackson stay on. We're going to listen to the whole clip. It's only 1 minute. I'm going to listen to it again so you guys can hear it without me pausing it and interrupting it. But think about what he says and listen to what he says. And we're going to roll that into what's going to happen after they walk off these steps.
Folks, this is what it looks like when you bring false charges against an innocent person. The Commonwealth did their worst. They brought the weight of the state based on spurious charges, based on compromised investigation and investigators and compromised witnesses. This is what it looks like. And guess what? They failed. They failed miserably, and they'll continue to fail. No matter how long it takes, no matter how long they keep trying, we will not stop fighting. We have no quit. Go ahead.
I just have two things to say, folks. Number one, I am in awe of the strength and courage of this remarkable client that I've had the privilege of representing since day one. And number two, I want to send a message to all of her supporters out there. Your support was invaluable. We are touched, and we ask for your continued support. I'm not from Texas, like my colleague here. I'm a Boston kid. But I'll repeat what he said, which is, we ain't got no quit.
No quit.
All right. So that's the comment in full. To me, I think the answer to this question is yes. I think they're going to stay on. I think they're going to figure it out. I really do. I think they are going to figure it out, how to make it work and stay on this case. Alicia Joe, if Lally changes his timeline in opening and tries to spin a new one, can the defense challenge it using the trial as evidence? So that's difficult to challenge what he said in a prior opening statement. I don't think there's really a way you can use that, except, yeah, I don't know if he can say they've changed their theory, if they can get that argument in somehow. But a defendant or a lawyer's arguments are not evidence, and you can't impeach a lawyer and ask them questions. So it's really going to have to come down more to McCabe and the other things that why Lally thought 10 or 1245 originally, because the evidence pointed to that timeline. And if he's going to switch that up, then there's going to be a lot they can impeach. Retrial, could the governor stop it? Not really. I mean, the governor, I guess, could pardon her if she gets convicted. But it's not really in the governor's purview to step in this situation. I guess he could try to use some leverage, but I would not expect that. Mary Claire, I feel that polling the jury and having that info made public, I think it's a female governor actually, so she, polling the jury and giving that info made public could inform the next jury. If it's a hung jury, I think that's info enough. Thoughts? Yeah, I don't want to affect any future trial, obviously. But it would be interesting to me if it was 10-2 one way or the other. And I think the two sides would want to know that. Any chance the Commonwealth decides not to retry since it just dirties up the police force again? I have heard that it's been reported that they've already decided they are going to retry her. Does anyone know what John O'Keefe's brother mouthed to Karen Reed on his way out? She looked angry. Thank you for covering this. People have said, I'm not done with you yet. I have no idea, though. I have no idea. Christopher Wells, if Michael J. Fox was healthy and could still act, he'd be a perfect Alan Jackson. I don't disagree with that. I saw a police dog trainer on YouTube say that John O'Keefe's injury were definitely from a dog. He showed the prosthetics they wear when the dogs bite. The bite marks were just the same. I have heard rumblings of this as well. Bride of Frankentruck. I think the DA has fired all their guns and are now at a major disadvantage. I agree. Some of their key witnesses are tainted. Can't imagine a conviction ever, and maybe more FBI discovery. And we know about these meetings that happened afterwards with Jennifer McCabe, talking to law enforcement even more. We know more about the timelines and more about the data with Colin Albert and Allie McCabe. So I think the defense is going to have more ammo round two. I think the prosecution's stuck with the same. Maybe they'll determine less is more and work with the keep it simple, stupid strategy, which I think would benefit them. Do you think it's odd that Lally didn't make a statement after court was dismissed? I mean, he's paying attention to probably the public, their perception, their backlash potentially. And I don't know. I don't know if I would want those arrows aimed at me. Yobi, do you have a P.O. box people can send you things? My office, it's on my website, tragoslaw.com. If you guys ever know anybody that needs a lawyer as well, car accidents, wrongful death cases, trucking accidents, give us a call. We'd be more than happy to help. We've gotten so many clients that we've been able to help through YouTube, and it's been truly amazing. And then you guys also send some cool stuff, which I appreciate as well. Robert said, you must realize that there is no justice in this world. Again, I disagree with this comment. I do think that our justice system can provide justice. It doesn't always. It's not perfect. But I also agree continuous retrials should stop. I don't know what the record is for like most retrials, but again, I told you we had a case where it got retried twice and eventually the judge threw out the case. So we'll see. I feel she had a horrible attitude. Her and her smirks have compassion on his family. She's a sneaky. I think there's more to it. What do you think? I have no idea. But I also understand that if you feel like people are wrongfully accusing you and trying to force you to go to prison for the rest of your life and you think you did nothing wrong, I understand why she would be frustrated by that. I do. Mia's Dolphin, can Jen McCabe change due to her timeline 12:27, 31:40, 42, 12:45? She saw Karen's car. Karen was at John's house 12:26, 12:36, the Wi-Fi connected. By the way, when we keep talking about this case, I'm definitely going to forget that it's 12:36 and not 12:26, so don't expect that out of me. But I think it would be hard for her to change her testimony, but she can become a little more vague. Like between 12:30 and 12:45, I saw her car a couple times. I'm not positive about the numbers or the times, and they can try to, impeach her. Colby, saw the info on when they must start a new trial. How soon could they restart? 1 week, 1 month, 3 months, etc. Thanks, Peter. They could start as soon as is reasonably possible with all of their calendars and all these lawyers. There's no limit to how quickly they could start the case, but from their own, physical and work limitations. But I would not expect it to be 1 week or 1 month. They're not even going to have a status hearing. It's going to take a month for that. So we'll see. We'll see. All right, folks, 2 lives in 1 day. Hit that like button if you haven't already. Thank you for coming and hanging out with us. Now that we know, in fact, it is a confirmed mistrial. We will continue to cover this case. As you guys have questions, send me stuff, tag me and stuff as it comes out. If we get juror interviews, of course, we're going to do breakdowns and recaps of that as well. I appreciate you guys. Are we going to get Trooper Paul again? I don't know how they have the case without him. And maybe he had something to do with them getting a hung jury. I don't know. But that's all I got. Until next time, hit the like button on the way out, and I'll see you then. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode,
People outside of this building have rights, and we know that they have voices. But this criminal trial will be decided by an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So, while public comment will likely continue, the rule of law will be upheld. People outside of this building have rights, and we know that they have voices.
And I said, why? And she said, well, you go to a dinner party with 10 friends and you bring up this case, and you can have 3 or 4 people who feel one thing, 5 or 6 people who feel another, and who cannot convince each other to feel otherwise. And she said, our jurors are a reflection of our community. You know, this is a jury handpicked from Norfolk County. They live in this area. And she, Jennifer Roman, I'm speaking about our legal analyst, was not surprised at all to hear that they have fundamental disagreements about some of the facts and in this case, and whether or not the Commonwealth had proved it beyond a reasonable doubt. And I said this earlier when I spoke with both of you, but I really can't overstate just how different today feels, and honestly the last 5 days of deliberations, but particularly today compared to the rest of this trial. The heaviness in that courtroom was potent. To come outside in the rain, to have no interviews with anyone involved in the case, just quick statements, and everybody rush out of here. And in that courtroom, the two sides that you were hearing could not have been more different. As the judge said, I'm declaring a mistrial. You heard a sigh in the courtroom, not a sigh of relief, like a sigh. And you saw Mrs. O'Keefe crying. You saw other members of the O'Keefe family crying. And then through the windows outside, you heard cheers. You heard just loud yelling, wooing, which we've been able to hear many times over the course of this whole trial, because the courtroom is right on the corner of the courthouse. So whenever there's been a siren or cheers from the group outside, even though they're past some 200-foot buffer zone, those cheers you can hear inside that courtroom. So to have those two sides happen as a mistrial was declared, you just can't really overstate how it was. Cheryl and Courtney?
WBZ's Christina Rex, thank you. And I think that she pointed out 2 interesting things. One, that we weren't expecting to hear from the DA's office this quickly. And I think that gives good perspective to our viewers who are not necessarily a part of the legal world. Maybe they haven't been following the case this entire time, so they don't know that we weren't necessarily expecting to hear from the DA's office. But also, she's letting us know that how different today feels. The feeling has been such an important part of the storytelling for our viewers.
Well, but I think that's normal. I mean, when you get to the point where a jury is deliberating, that's when it becomes really real. Mm-hmm. I mean, while the testimony is going on, it's part of the process. And now you get to the end of the process, and there's a lot riding on this. You know, her freedom, Karen Reed's freedom is riding on this. You know, John O'Keefe's family wants justice, and they believe justice is a guilty verdict in this case. So you can understand the pressure that everybody is feeling. You can also understand the weight of all of that and the responsibility that these jurors feel to come to a decision.
Guys, if you can hear me, take our live shot. The O'Keefes are going to leave court.
Now, I do know that we are working on, we are talking to our crew in the field right now. We want to get you back out to the courtroom. We are being told that the O'Keefe family is coming out of court now. So let's just wait a moment. But while we are waiting, this is, again, just a reminder that this is not over. This is not over for the O'Keefe family. It's not over for the Reed family, friends, supporters.
And you can imagine, I mean, this is you saw the emotion. We showed you the video inside the courtroom. The O'Keefe family very emotional about the mistrial. The Karen Reed's family very emotional about the mistrial, and also knowing that there's still another process that they all have to go through again. So no, this is not the end for anyone in this case. You can see them filing down the courthouse stairs right there with family. Difficult day all around. I mean, at the end of the day, someone died here, so it's very sad.